Historical development of ADR in India. Introduction. India, with its rich tapestry of cultures and traditions, has a long history of dispute resolution. From ancient indigenous systems to the formalization of modern ADR mechanisms, the journey reflects the intricate interplay of cultural practices, colonial influences, and contemporary legal developments. This comprehensive note delves into the historical development of alternative dispute resolution in India, tracing its roots from traditional dispute resolution practices, navigating through British colonial influence, and culminating in the present era of modern ADR legislation, institutional growth, judicial endorsement, challenges, and future prospects. Traditional dispute resolution in India. Long before formal legal systems were introduced, India had a robust tradition of resolving disputes through indigenous mechanisms. Village councils, known as panchayats, played a central role in adjudicating disputes. Comprising respected elders and community leaders, panchayats facilitated dialogue, emphasized consensus, and focused on restorative justice. This decentralized and community-centric approach was deeply ingrained in the fabric of Indian society, promoting harmony and maintaining social order. The traditional concept of Nyaya panchayats in rural areas and the Panch Parmeshwar system in Rajasthan exemplify India's historical reliance on community-led dispute resolution. These systems emphasized the principles of fairness, equity, and community participation, providing valuable insights into the foundations of ADR in the country. British colonial influence. With the advent of British colonial rule, India witnessed a significant shift in its legal landscape. The British introduced formalized legal structures, rooted in adversarial principles, which replaced the traditional community-centric approach to dispute resolution. The British legal system, while bringing uniformity, also led to the marginalization of indigenous methods. The Civil Procedure Code of 1859 and subsequent legal reforms reinforced the Western model of litigation, sidelining traditional practices. However, certain elements of ADR persisted, with courts occasionally encouraging arbitration and mediation in specific cases. Post-independence era. Post-independence, India grappled with the challenge of aligning its legal system with the diverse cultural and social ethos of the nation. The need for a more efficient and accessible dispute resolution mechanism became evident as the judicial backlog increased. The Law Commission of India recognized the limitations of the adversarial system and advocated for the promotion of ADR methods. The 129th report of the Law Commission, released in 1988, laid the groundwork for the formalization of ADR in the country. It recommended the establishment of arbitration and conciliation mechanisms to alleviate the burden on the judicial system and foster a more amicable resolution of disputes. Introduction of modern ADR legislation. The turning point in the evolution of ADR in India came with the enactment of the Arbitration and Conciliation Act in 1996. Aligned with the UNCITRAL model law, the Act aimed to promote arbitration and conciliation as alternative modes of dispute resolution. It introduced a legal framework for the enforcement of arbitral awards, and recognized the autonomy of parties to choose their dispute resolution mechanisms. The Act provided a structured process for arbitration and conciliation, outlining the roles of arbitrators, conciliators, and the enforcement of awards. This legislation marked a paradigm shift, acknowledging the importance of ADR in alleviating the strain on the overburdened court system. Institutional development. In the years following the enactment of the Arbitration and Conciliation Act, institutional frameworks for ADR proliferated. A notable example is the establishment of the Indian Council of Arbitration, ICA, in 1965. Which aimed to promote arbitration and conciliation in commercial disputes. Subsequently, various institutions such as the International Center for Alternative Dispute Resolution, ICADA, and the Delhi High Court Mediation and Conciliation Center, DHCMCC, were set up, further institutionalizing ADR practices. ICADA, established in 1995, plays a crucial role in the promotion and development of ADR mechanisms in India. It provides training, research, and administrative services for arbitration and conciliation and has contributed to the growth of ADR expertise in the country by the judiciary. The judiciary in India has played a proactive role in promoting ADR, recognizing its potential to provide expeditious and cost-effective justice. Judicial pronouncements have consistently endorsed the use of ADR mechanisms, emphasizing their utility in resolving disputes, particularly in the context of commercial matters. The Supreme Court of India, through various judgments, has recognized the importance of ADR and has consistently encouraged parties to explore alternative modes of dispute resolution before resorting to litigation. The case of Afghans Infrastructure Limited v. Echerian Varki Construction Company, 2010, is a landmark example where the Supreme Court underscored the need for promoting arbitration and conciliation as a means to reduce judicial pendency challenges. Despite the significant strides in the adoption of ADR mechanisms, several challenges persist. One major challenge is the lack of awareness and acceptance, especially in rural areas. Traditional practices continue to coexist with formalized ADR, creating a need for sensitization programs and educational initiatives. The issue of enforceability of ADR awards and the perceived lack of confidentiality in mediation proceedings pose additional challenges. The need for a cultural shift in the legal fraternity and among litigants to embrace ADR as a first resort rather than a last resort is an ongoing challenge. Moreover, the absence of a comprehensive legislation specifically addressing mediation, coupled with the lack of a dedicated regulatory body, hampers the growth of mediation as a preferred mode of dispute resolution. Future prospects. The future of ADR in India holds promise, with ongoing efforts to address challenges and enhance the efficacy of ADR mechanisms. The proposed amendments to the Arbitration and Conciliation Act aim to streamline procedures, address ambiguities, and enhance the enforceability of awards. Legislative developments specific to mediation, such as the introduction of the Mediation Bill, underscore a commitment to strengthening the mediation framework. Technology also presents opportunities for the evolution of ADR. The use of online dispute resolution (ODR) platforms and virtual hearings has gained traction, especially in the wake of the COVID-19 pandemic. These technological advancements can enhance accessibility and efficiency, making ADR more convenient and inclusive. Conclusion. In conclusion, the historical development of ADR in India reflects a journey from traditional dispute resolution practices to the formalization of modern ADR mechanisms. The shift from adversarial litigation to collaborative methods signifies a recognition of the need for accessible, timely, and cost-effective justice. The legislative reforms, institutional development, judicial support, and ongoing initiatives indicate a growing momentum in favor of ADR in India. While challenges persist, the proactive measures and the evolving legal landscape suggest a positive trajectory for the future of ADR in the country. As India continues to balance its rich cultural heritage with modern legal principles, ADR stands as a dynamic and integral component of the broader quest for a more efficient and harmonious justice system.